Hi, everybody. This is Mr. Hall, and I am starting the first of a number of videos that I will be making for you to keep you up to speed with what we are doing in ENT 103. And so we're going to pick up where we left off before we went on our spring break, which ended up being an extended spring break. But I'm going to pick up where we left off and just cover the rest of Chapter 8 for you for this week. So what I'm planning to do again for the course is just I'm going to post all of these videos as I go through each chapter, and I want you to just look at the videos and listen to what I'm talking about in the videos, and I'll go through with the slides. The second thing is make sure you go onto your course page and go onto the weekly modules. And although the dates are not going to be perfect because of all the changes that we've had in our schedule, we're still going to be following it step by step, and look for announcements to keep you posted on the exact dates of things that are due. We also will be doing a lot of Zoom meetings. So I'm setting that up now, and we'll be having them each week for you to ask questions. Those meetings will not be for lectures necessarily, but are going to be more for an opportunity for you to ask questions about the course or anything about the subjects that we're talking about. So here we go into Chapter 8 again. I'm going to continue with Chapter 8, and as you can see on your screen, we have the types of discrimination that are listed, and we talked about disparate treatment and disparate impact, and that was what we talked about right before we went on break. And as we look at this, it says, again, disparate treatment is the difference between disparate treatment and disparate impact is disparate treatment is that we need to prove that the employer intentionally discriminated by denying employment under any of the 5 categories that are covered under Title VII of the Civil Rights Act of 1964. So intentionality is the big difference between disparate treatment and disparate impact. Again, in disparate impact, there's something that's happening that we're doing maybe that is resulting in discrimination, but it wasn't necessarily intended to be discriminatory, and that's really, really important to discriminate between the two. So intentionality, and we talked about that right before we went on break. That was our last session that we talked about, was that type of discrimination. Moving forward, the next slide is really about harassment. And we've heard this term quite a bit in the political news over the last year or so, is the term quid pro quo, which again it always means something for something. So quid pro quo is, to read from the slide again, job-related adverse action to retaliation for a person's refusal to respond to a supervisor's sexual advances. So it's something for something. For some kind of a sexual advance, we'll give you, I'm going to give you the promotion, or I'm going to give you the bonus or whatever, other thing that you could be using as leverage. In a quid pro quo situation, there's always an imbalance of power. So there's someone that has less power than the other person. And so quid pro quo always is a difference in power. A hostile work environment, again, I think we talked a little bit about this the last day, is, again, just to refresh your memory, was an environment that is uncomfortable for someone, and there were the 3 criteria that need to be met with that. The first is that he or she was subjected to some kind of sexual conduct. Number 2, and this is an important one, the conduct was unwelcome. And number 3, the conduct was sufficiently severe or pervasive as to alter the conditions of the victim's employment and to create an abusive working environment. So all 3 of those criteria need to be met. So as a leader in your business, if someone should come to you and say that they feel uncomfortable and that a particular other employee's behavior is unwelcomed, it is then therefore, by a legal standpoint, your responsibility to be able to go to the person that's doing the sexual conduct, and you need to address that. So you do not have the option to not address that once it's brought to your attention. Now, again, the perpetrator of this is not liable if they've never been informed that it's not welcome. So, that's important, whether it's the person that's being victimized that expresses it to the person, or whether they come to you as a supervisor or an owner and you go to the employee. But it is required that you allow that other person to be aware that it's not welcome. Once that's been done and that's been established, again, I would always encourage you to keep some kind of a written document about that. So keep some kind of a written record, have the employee sign it so that they say they understand it. That gives you leverage for if something should happen again, you can go ahead and fire them or demote them or reassign them, and you have the legal leverage to do that. So I think that's a very important point as well. What about retaliation? When we have retaliation, retaliation to any kind of a complaint, we need to protect the victim in this as well. So, we really, it's by law, it's prohibited for employers from retaliating against employees for asserting their Title VII rights. So if someone, has claimed a Title VII of right violation, has filed a complaint either with the EEOC, they are immune from you retaliating against them. So there can't be some kind of an action that would demote them or fire them or anything if that's been filed. Now, that will be reviewed by the labor board, and at that point they can determine whether there's been a violation or not. But be careful that if someone has filed a complaint, they've gone to the labor board, it's been reviewed, and it's found that they didn't have grounds for that. Be very careful about treating them differently when they come back. You should just move forward, but I would not retaliate against them, even if they found that you were not violating any of their Title VII rights. There is a defense under Title VII, and we talked a little bit about this, but I'm going to really touch on it now. And this is a really, really important point. It's called the bona fide occupational qualification, or a BFOQ. An employer has the burden of showing a reasonable basis for believing that persons in a certain category are excluded from a particular job or unable to perform that job. So if you have guidelines in regards to a job that you are looking for, and people need to meet certain qualifications in order to do the job effectively, you can discriminate. Again, remember, the discrimination word means that you're selecting one person over another. And for some reasons, they can be quite legitimate reasons. What we're trying to defend against are disqualifying people for reasons that have nothing to do with the job. But if you're disqualifying people from a position because they're not able to meet the job requirements, then it's not discriminatory. So if you, for example, have a loading dock that requires loading dock workers to be able to move boxes that weigh minimum 60 pounds from trucks that are delivering them to your cargo bay, and you have applicants that are not physically large enough, whether male or female, it doesn't matter, that are not strong enough or able to lift boxes that are 60 pounds, that would be a bona fide occupational qualification. So if they're not able to do that, you can disqualify them from the position, and there's nothing that can disqualify them from that. So that's what a bona fide occupational qualification is. I think I used an example at one point in class of, if you're operating you're leading a church, and the church is like our church right now is looking for a new pastor. It's a Christian church. It's a Protestant Christian church. If someone from a different faith would come and apply, and we didn't accept them because of their faith, that would not be a violation of Title VII, because that's a bona fide occupational qualification that a person who pastors a Protestant church would be someone in the Protestant faith. So, those kinds of things are what we would consider a bona fide occupational qualification. So it can go more than just physical attributes. It can be other things as well. Let's shift a little bit more to another subject that this particular chapter discusses, and that's age discrimination. So we do have an Age Discrimination and Employment Act, and again, just to kind of remind you, I'm doing these videos not in place of the chapter, but to help you follow along. So I hope that you are still utilizing your book as a very important book for you to keep, and I want you to keep following that book. So our Age Discrimination and Employment Act, all companies that perform interstate commerce with at least 20 employees are subject to evaluation on age discrimination. So if you are a small company of less than 20, interstate commerce means that you do commerce outside of just your local area, then you are part of that. But if you're smaller than that, you may be exempt from some of these rules. The Age Discrimination Employment Act, any employee that are age 40 or above are qualified under this. The questions to ask are, was the person that applied particularly qualified for the job or not? Did they suffer an adverse employment action, or were they replaced by a significantly younger worker? What we see in these kinds of issues are always related to pay, typically. So what we see is some companies will discriminate against somebody that's older, simply because older means more experience, and when you get more experience, you typically will demand a higher salary. So some companies will try to save money by firing someone who's older, who might be making more money, and hiring one or two people in their place that are much younger. So that can be an issue, and so that's why they put this act in place. Of course, as you know, the baby boom generation, which I'm actually part of, a very young part of that, but I'm at the very edge of that age category. As we get older, we continue to work longer. So this is becoming much more of an issue as we have gotten older. For age discrimination has become much more of an issue. We're seeing that rise more and more in relation to age discrimination. The next thing in your book that they talk about is the Immigration Reform and Control Act. So it's unlawful to discriminate against applicants or employees on the basis of their national origin or citizenship status. So we do protect, and this is always a big touch issue right now as well. So we can require people to be a citizen or have some kind of citizenship status to work for us. In fact, they are by law must meet certain qualifications. But we do have immigrants, as you know, that come to our country and work in our country, and they get green cards. So as you can see, it protects U.S. citizens, but also permanent residents, temporary residents, asylees, and refugees from citizenship status discrimination. So if they are following policies and are okayed to work, you can't discriminate against them and say, I'm not going to hire them because they're not a citizen, even if they are qualified to work legally in the country. This does not cover illegals, people who are not here lawfully, or people who are not U.S. citizens or have not filed the correct forms in order to allow them to work, like a work visa. So people that are coming that can legitimately work for any business has to have some kind of a work release or work visa that can be verified and should be verified by the employer. Be very careful with this, because you can hire people that are not allowed technically to work here legally, and if you get caught, you can be in a lot of trouble with that. So I have a cousin that works in landscaping. He hires crews. A lot of these, particularly men, come from Mexico every year, but they come in legally, and they have legal status to work here as seasonal workers and are great workers. And he has to verify every year through the immigration services that they are legally permitted to work for him over the summer. So it's something that you as the owner has responsibility for. We're going to stop this video because they have to be 15 minutes long. So we're going to stop this video, and then I'm going to give you a second video that will start with the American with Disabilities Act. So thank you for tuning in, and be ready for the next video as it's coming. Thank you. Bye.